I would now like to introduce our first speaker for today. Mr. Mauro Rubino-Sammartano was born in Milan, Italy in 1937. He was educated at the Catholic University of Milan. His previous offices include the Recorder of Desio and in such capacity a judge at the Court of Justice in Monza. He has also taught international arbitration at the universities of Padua and Milan. He is an associate tenet of Littleton Chambers of London as an international arbitrator. In addition to being the president of the European Court of Arbitration, he is also chairman emeritus of the Union International des Avocats, chairman of the IBA International Construction Contracts Committee, and has also chaired two other IBA committees, the Sales Contracts Committee and the Mediation Committee. He is also Secretary General Emeritus of the Federation of European Bars. I would now like to invite Mr. Mauro Rubino-Sammartano to the podium. Thank you.
Attorney General, representative of the judiciary, authorities, dear Rotarians, ladies and gentlemen, dear colleagues. It is always a great pleasure for a Mediterranean to be in the middle of our sea, what in Latin is called mare magnum, also because over the centuries we have learned our few qualities and our many defects. I'm very grateful to the judiciary and to the government for what I do not hesitate in describing a friendly approach to arbitration, provided it means to help justice to be made. Some words about the European Court of Arbitration. It will be only a flash, but I think in view of the time, it will be welcome to be short. Now, the Centre Européen d'Arbitrage et de Médiation is a legal entity formed in 1959, it was said in Strasbourg, where it still has its seat. It has departments which are European Court of Arbitration, the Mediation Center for Europe, Mediterranean and the Middle East, and the International School of Arbitration and Mediation. Its territory is Europe, the Mediterranean, and the Middle East. I'm grateful to the Attorney General for having mentioned the Black Sea, which I was forgetting for a moment. This shows that he has studied the file very carefully, more than he deserves. Thank you. Now, the court has various national chapters or délégations, say in French, and you will see several are in Europe, like France, Germany, Iraq, Spain, Turkey, if you wish, Greece and Cyprus, Belgium. Others are in Lebanon, Turkey, Syria, and Iraq and Egypt. I would like to mention an objective remark made by my friend, Professor Lalive, who at his time, in my opinion, has been the best arbitrator we had, certainly in this part of the world and probably in the entire world. And he used to say very openly, there are too many arbitration centers. And to me, this comment is right when these centers have, as they do, the same rules. Our body has rules quite different from the great majority of the other ones. I believe they are better, but of course I don't say it. If I could try and describe in 3 words the essence of our approach to arbitration, is that arbitration in no way must be a luxury clinic. I regret to see that many arbitral centers, to the contrary, love to create an image of a luxury clinic where few surgeons do very special work for a lot of money. This is not our purpose. We believe this is not the way we serve the country and the public. I'll try and describe to you in few words which are what we call as the main points, and which have already been kindly mentioned by the Attorney General. The first one is a sole arbitrator. Now, there is a sort of a love by many, many people to have 3 arbitrators, because they say, fine, each one can appoint his own arbitrator. So there is sort of symmetry, which, according to the old and beloved Greek civilization rules, it's a sign of harmony. However, this is not so, in my opinion, because first, it costs 3 times more. One is cost 1/3 of 3. But this is nothing compared to the fact that when you appoint your own arbitrator, many of us, since we are not all saints, put some pressure on him, and frequently he's not impartial. And therefore, we end up by a panel of 3, out of which 2 are not entirely partial, too generous. Now, another main point is a duration. Now, the average, and I'm not saying something new, is above 2 years. Frequently 3-4 years, and in some cases even 10 years. Once I was acting as an advocate, had a case involving the state of Kuwait. It lasted 10 years. Well, I admit that there was a war, and therefore that we must detract 1 year, but 9 years. 9 years is not acceptable, frankly. So our duration, depending on the delegations, but in general it's 9 months, plus very exceptionally up to twice 6 months postponements. And the reason is that some types of disputes, like construction disputes, are very long. Also because, as some of you may know, experts are entitled to as much time as they want. Lawyers must run, but experts enjoy a very special treatment. Don't tell me why. Okay, another point, one of our main points, is oral evidence. You know, very frequently in the rules of arbitral centers, nothing is said about it. And the excuse is that they prefer to defer to the arbitrators, which makes no sense. Because if you take an international arbitration with an arbitrator from Europe, another one from China, and the third one from Australia, they will never have time nor the pleasure of discussing amongst themselves which is the best way to take evidence. Now, oral evidence is a delicate issue for those who are involved in the law. As you know, in some jurisdictions, like for example France, all what you get in terms of evidence is a witness statement, une attestation. Is that enough? Is it right that the judge and the parties cannot check a bit more about what the witness has written and who has written it? Because frequently, like in common law jurisdictions, in the end it is a lawyer who writes it, and the witness finds out at the end that not even one of his words has been put into it. Maybe the substance, but not his words. Then in other countries, in other jurisdictions like Italy and others, there's a judge-dominated taking of evidence, because the judge, thank God, knows how many witnesses will be necessary, which questions must be put, and in the end he examines themselves, which is definitely wrong, because he has not the burden of proof. So if the party has the burden of proof, she's entitled to discharge it. If you avoid that, to me it's a splendid academic examples of a denial of justice. Therefore, we have examination of witnesses and also the parties, which in some civil law jurisdiction is not admitted, because the party can be taken as serious only if she admits something to her disadvantage. And then, of course, cross-examination, strictly in line, I would say, with the English rules. Then we have documentary evidence. And here, too, you have opposite situation, because in the United States, as you know, there is full disclosure. while in several jurisdictions there's practically no discovery. We have tried to find a solution which combines the positive elements of each of them, and therefore we have a limited discovery, under control, and sanctions. And then one of our main points is a review of the award. And generally, a review of the award is allowed only for procedural irregularities and never a review on the merits. On this, there's a sort of general consensus. And the award is looked at as a sort of taboo. I remember many years ago, I was trying to explain to the AAA, the American Arbitration Association, the advantages of this, and the response was, oh no, arbitration must be one shot. And one shot is perfect if you win, but it is not perfect if you lose. And why should one not have a second round? So we have a second appellate degree with a full review of the merits, with a requirement that in order to be allowed to have the appeal heard, the loser must deposit the money with our clerk or with the bank, and it will be paid on the very day or the following day from the decision to the party who wins. And the effect of this is that the successful party receives immediately what is provided for in the award, without having first to obtain enforceability and then to try to enforce, resisting to various oppositions. And this has always been, to me, the impossible dream of arbitration. Which are the reasons in favor of the second degree? Because everybody, as I said, was against it. Until recently, the European Commission, in the matter of investment disputes, said it is absolutely necessary that the decision be reviewed. And I'll start with a question which is very simple, which is why parties refer dispute to arbitration? Each of us has his own reply, and I would venture and offer one, because they look at proceedings which will be better than state court proceedings. And this having been said, arbitrators are normally, even if not always, I could mention names of someone of which I have some doubts whether he's a human being, but anyway, they are normally human beings, and therefore they make mistakes. And if we want to offer to the citizen a service which is better than court proceedings, then if we allow no appeal while in court proceedings, the appeal is a matter of right. Are we better or are we worse? I've suggested that we are worse, but obviously it's up to you to decide. Then a last point, which is of great relevance to us, is which approach is required from arbitrators. And the general approach is frequently to magnify themselves, and the arbitrator loves to write something very learned which can be allowed to be admired. Or, for lack of imagination, they do things which maybe are not the best one in court proceedings. Now, in my opinion, in the opinion of the court, which I have the honor to preside, the duty of an arbitrator to us is to decide with humility and humanity. Thank you for listening.